Hey y'all, hey, what's going on? We're back again. Oh, with more Boone. But before we get into that, welcome. Thank you guys for being here. I appreciate your support. If you haven't done so already, give your girl a thumbs up on the stream. I'd appreciate that too. Or give me a thumbs down. There's always one. I went and looked at my dashboard today and I forgot what I was looking for specifically, but I noticed that I have like 99.9% thumbs up. So I was like, what? So I went and looked at it, and like there's literally always one thumbs down. I don't know what that's about, but hey, I don't judge. If it makes you happy to give my video a thumbs down, thumbs it down. If you like it, I love it. That's all I got to say. Welcome in. Boss lady, are you evacuating, babe? I'm sorry to hear that. I don't know if I'm supposed to be evacuating or not because, to be quite honest with you, I probably should pay more attention to that. But the way it works at this household is my husband has to work. And so by the time his work would even let him off to evacuate, it would be, not worth it. And I think we're far enough inland, I think, and away from, we do have a river here. And of course, there's the beach. I'm not that far from it, but where our neighborhood is situated, I think we're okay. We'll be okay because we've had some hellacious storms. And so if you are in the path of the hurricane, don't be like me. Do what emergency management tells you to do. If they tell you to evacuate, get your ass out of there, evacuate, go on. Take your pupsters with you if you have to evacuate for a hurricane, and you have animals, the hotels have to take your animals. So, know that. Stay safe. If you plan to stay, be prepared. Get water, get batteries, candles, get canned food, that kind of stuff. So everybody stay safe. I'll stay safe too. I think the way that it's coming, we should be all right. I don't think that it's going to have an impact on Sarah Boone's hearing that we're all waiting for on the 26th, which is Thursday, because it won't start getting to my part of Florida, which is across from Sarah's part of Florida. She's in the middle. I'm on the Gulf Coast. Till the afternoon, and I believe her hearing is scheduled for in the morning. If it's not, we're going to go and look at the Orange County clerk, so I'll know for sure. But everybody, please stay safe, okay? Stay safe. All right, so the first thing I was thinking we should do is, not everybody was here to be able to see Sarah's, to see the hearing that took place today. Now, this hearing was not about the case. Okay, this hearing was Cashman, Hobson, and Bankowitz, which are her three former attorneys. They're requesting to be paid from the JAAC. And the reason that I found it so interesting, and I wanted to stream it in the first place, is because I was hoping that the attorneys would speak on Boone herself and why they filed to withdraw. And I was not disappointed. They did. All right. So, preschool granny, member for 10 months. That went by fast. I love it here. Well, I love having you here. So thank you for being here. Thank you for supporting me and the channel for 7. I'm looking at the chat for 10 months. I appreciate that, babe. All right. Boss lady says, yes, in Wakulla County and work in Tennessee. I'm 7 miles from the Gulf, moving to a hotel down the road Thursday morning till Saturday. Good. You'll be safe and sound there. Good. Okay. Yeah, it's, It's going to be a quick one, but a strong one. So everybody stay safe. Okay. So now let me go ahead and share the screen for you guys. This hearing isn't all that long. So we're going to watch that really quickly. It's, I think, 10, maybe 15 minutes. And then we will watch, or we'll talk about this new motion that was filed that I'm already feeling some type of way about. I'm quite disgruntled. I'm not even going to pretend that I'm not. I'm annoyed. So there's that. All right, let me add this to the screen and let's go.
Next up is 2020 CF 2603, State of Florida versus Sarah Boone.
By the way, just so you guys know, in the settings, I have it to, where is it? What? I did have, oh, it won't let me. Usually I have stable volume turned on, so it doesn't do that when the volume is not good. I will tell you that they're meeting on Zoom. And so when some of the attorneys speak and the representative from the JAAC speaks, it's a little bit loud. So stay by whatever apparatus you use to turn the volume down and adjust your volume accordingly. All right, now for reals, here we go. Okay, here we
go. Mr. Lake, you're here on behalf of JAAC.
I am, Your Honor.
All right, and Ms. Cashman, you're here on, as one of the attorneys on the case.
I am, Your Honor. I'm assuming that, like the last attorney, I will be permitted to stay seated because of the microphone issue. Thank you.
Although I do recognize you're probably like me, it's hard to argue while you're seated.
It's a very unnatural feel.
Who else is here on Ms. Boone's case?
Frank Bankiewicz on behalf of Mr. Boone. Judge, I believe I said in my notes here, attorney number 7, but I think I was actually attorney number 6 on the case and had the case the longest of the 3 of us that are appearing before the court now.
All right, thank you. And Mr. Hobson, you were.
Okay, for anybody that's confused or not, doesn't, why we have a different judge. This judge specifically handles, since these attorneys are no longer on Sarah's case, it would not be appropriate for Sarah Boone's trial judge to handle this hearing. This hearing is so that the attorneys can state their case as to why they feel they should be paid at the rate that they want to be paid at. And then the JAAC gets an opportunity to ask some questions, and then the judge makes the ruling. But that's why it's a different judge. Not, yeah, exactly. This exactly right. Yana. So, Judge Munyon. What is wrong, Jen? Judge Munyon is chief judge. This is administrative work, not a part of the criminal trial. Correct. So she's going to handle this for us, and then we're going to get into this is important, but other stuff is more important. KPM, I have. Would you guys like to talk about that? About the autopsy. I didn't know if anybody, if you guys would be up for that, or if you wanted me to do a separate live just to discuss that. But if you want to talk about it, we can absolutely talk about it. Of course, I'm willing. Absolutely. And I have had a chance to go over it. Yes. All right, here we go.
Court appointed to Ms. Boone at some point during her saga as well.
All right, we'll go over it then.
Yes, Your Honor.
Her saga.
Mr. Bankiewicz withdrew. I was appointed.
All right. So we have all 3 of your bills, and I know JAAC had indicated they had no objection to Ms. Cashman's bill, but I did not get a similar statement with regard to Mr. Bankiewicz or Mr. Hobson. So I thought I needed to have a hearing with all 3 of you present. I am.
Right.
Mr. Lake?
I was going to say, there is an objection here because essentially what we're at this point is this is compensation in excess of the flat fee because there's 3 attorneys involved. So
there's no line item objections per se because these are all flat fee bills, but we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent.
Right. And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many attorneys and has, according to Judge Kranick's order, sabotaged those relationships. And accordingly, attorneys needed to withdraw and new attorneys were appointed. And I do recognize that a lot of work was done for Ms. Boone. So we will start with Mr. Bankowitz, then move to Mr. Hobson, and then to Ms. Cashman.
Thank you, Your Honor. Basically, I had the case for a little over a year. I had 175 hours in the case, including actual 45 hours at the jail with the defendant. When I received the case, I got a box of crazy information, I'll put it that way. And it was an entire file box, and it took weeks to go through it, categorize it, and kind of figure out what was going on in the case at that point in time. She originally had a privately retained attorney, and I basically received his case and his file because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees, and because they did basically nothing on the case. The three of us did a lot of work in the case. As I said, I put in 175 hours, and even at the $75 an hour compensation ratio, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time on the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankowitz, and I got the same information. The information Mr. Bankowitz just recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay. That it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theories of defense. In fact, you combine the information from the expert divorce attorney that was privately involved and took the case to right up to the edge for trial, and then had to back out. So I had that information, those boxes or box of information Mr. Bankowitz talked about. I had those. I had to go through those. I gave all that material to Ms. Cashman plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all angles. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day. Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory, and it was a constant battle going back and forth. You had to deal with the gaslighting.
Okay. And there it is. Okay. I think that is as close to understanding what the ethics meant when what these attorneys meant by, excuse me, saying um, irreconcilable differences, also, as well as I can't remember exactly what they said, something having to do with ethics. Oh, wow. Thank you, Lynette. That's so sweet of you. I appreciate that. Where to catch you live, be safe from a neighborhood or in Tennessee. Thank you for all that you do. Thank you so much. That was very generous. Thank you so much. Thank you. I appreciate that. So sweet. I think that we hear it with Mr. Hobson there. You know, the crux of the issue between Sarah and her attorneys is her interpretation of the law versus their interpretation of the law. And of course, you know, Sarah, who to her, these are her own words, I excel at everything. Well, you're not an attorney. And this is why when she got, you know, when she would speak in court, when she was pro se, or when she would write motions and remind the court and the judge really that, you know, she doesn't have any experience in being a lawyer. She hasn't worked in the legal field at all. Then why are you arguing with people who have, Sarah? Why? This could have been done and over with a long time ago, but here we are. And then this gaslighting business. Now that I want to talk about because gaslighting is a word that's used a lot. And I've also noticed that it is used incorrectly. Arguing or debating facts is not gaslighting. Okay. Gaslighting is when something has happened and you try to convince the other person that not only did it not happen, but the fact that they believe that it happened, they're crazy for that. That is gaslighting. A good example would be the only one that's coming to mind right now is Betty Broderick. Betty Broderick was gaslighted by Dan Broderick. She would ask him about him cheating with Linda. And he would tell her, no, I'm not cheating with Linda. And I can't even believe that you're asking me that. You are crazy. And that is what gaslighting is. I feel like Mr. Hobson probably is using the term correctly when it comes to Sarah, because we've watched Sarah in court and in paperwork from the jail hear a statement, be told something, and have a completely different interpretation of events every time and argue and say, no, I didn't say that, when you know you did say that. And it's recorded. That's what's annoying to me. So I feel like he's telling the truth and he's using the word gaslight correctly. But oh, hey, Allie, good to see you, babe. But yeah, I mean, I feel that Sarah Bellum says, I argue that she is gaslighting, and that causes a huge ethical dilemma. You know, I would agree with that because, like, we've seen Sarah do it, you know, and we're going to get into it a little bit later with the whole situation that's with the filings that just happened. But basically, I just wanted you guys to hear what these attorneys have to say. So I'm going to get back to it, and I'm not going to, pause too much. I have to do it a little bit for commentary and fair use purposes, but I'm going to let these attorneys speak. Let's rewind this a little bit and hear what Mr. Hobson has to say about this. Okay, hang on just a second. I'm going to rewind it.
And so I was looking at the case from all angles. I gave all that material to Ms. Cashman plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all angles. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day. Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it was a constant battle going back and forth. You had to deal with the gaslighting. Um, and I told Judge Kranick at the time that I withdrew that it's just was too much. This case required at least 2 lawyers. I told that to Judge Kranick, plus possibly an assistant. I see now the case has 3 lawyers, plus experts that we worked at getting, plus investigators. So everything they're doing now, we attempted to do. We made every effort to do all those things. Ms. Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Bankowitz. We did just put in a tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any person that worked with you on this matter. And I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding $75 an hour. I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case we come to the court on regarding fees. But this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant and coordinating the defendant's thoughts on how things should go with what our experts were telling us and our investigators were telling us. So I believe the flat fee for each attorney would be anything less than a flat fee would be totally confiscatory, Judge. Thank you so much.
Thank you.
Okay. Now, I listened to this morning and I feel awful. Now hearing Mr. Hobson explain it this way, just really get down to brass tacks and say what they had to go through. Not just the attorneys themselves, but their staff. I feel bad for them. I do. And I think that I don't know what it is that changed. I think that Mr. Owens is such a spectacular attorney that, you know, he is the unicorn in a sea of attorneys that caused Sarah Boone to see the light. No, I'm going to tell you what I think. I think that Sarah Boone, when she had to sit in that courtroom and represent herself, and the judge denied her motions over and over and over again. And once she got her pause on the discovery, which is what she wanted in the first place, Letitia, I think, in my opinion, which I think she realized that she was completely over her head. There's no way that she could present a case. And I think that when Mr. Owens came along, and I think Sarah was like, my back is against the wall, and this guy is handing me a life preserver, and I'm going to take it, honestly. Which I don't know how your back can be against the wall and you need a life preserver, but you take my meaning. She knew she was in trouble. She knew that she wasn't going to be able to do this. And I think it's out of desperation that she accepted the help and is sitting there quietly, because at the end of the day, she only has to work with him for about 30 days. And that's about Sarah's limit. She can only, excuse me, comport herself properly for about that time. And then she's done. And we know that even then, she hasn't been 100%, a bowl of cherries with Mr. Owens, because we read in the report from the jail that on one of the visits, they were arguing, and it got so loud and it was so disruptive that a bailiff, or I mean, excuse me, that an officer had to come in and say, "Hey, what's going on here?" So I think that, that is, that speaks volumes. Also, I wanted to say, happy anniversary, Mayla's mom. Congratulations, 8 years. And you're right, Yana. It's not just the attorneys and staff that she caused trouble for. One of them said she caused problems for his family. That was Bankowitz. Mr. Bankowitz said that. Now, I don't know what he never got. It never went any further than that. But yeah, and I want to point this out too, because this is, you know, um, important information to know moving ahead. First of all, I thought it was incredibly smart of Hobson to interview people, to get their take on what they'd heard on the case, because it is like a sampling of a jury pool. Okay. And it is a good idea to see how regular everyday people, and I'm talking about people who aren't, we're all regular everyday people, except for the fact that we follow true crime. And so that gives us a different perspective. These, most of the time, people that sit on juries they don't actually, I mean, more than seeing a blip on the news and then that's it. They don't take to the YouTubes and go and do a full ass deep dive or anything like that. So, I think that's the difference. And I thought that was a good idea. And I think that what I can't state this enough, and I know I sound like a broken record, but I just have this feeling that come hell or high water, Sarah is going to haul her cookies up on that stand, and it is going to go horribly. I mean, we're talking about a situation where it isn't like Sarah is free, okay? So it's not like she is able to drop by these attorneys' offices, okay? She is in jail behind bars. She's got um limitations, and yet still managed to make these attorneys' lives miserable. you know? And so I feel like that speaks volumes. And oh gosh. And yes, absolutely, Black Eagle, the awesome uppity, a whole, and we'll be here for it. Yes, we will. Every day, every minute, every hour of all of it, we will be here for. KPM, to answer your question from earlier, I don't have anything in the report that I got that says anything about what was in the suitcase with George, by the way. So if you could send me that page to my email, por favor, I'd really appreciate it, because I haven't seen that. And I also agree with you here. Then she will file an appeal and throw these attorneys under the bus. She absolutely will. It will never be good enough for Sarah. I do too, Phoenix. I feel like, Phoenix says, I feel so badly for laughing about how she legit gave these defense attorneys PTSD. I think that when they filed and the hearing was had on their motions to withdraw, I don't, they were doing their job in that they were still protecting their client, and they didn't go into great detail about what happened. And so the public didn't know, which is why I'm glad that I watched this and I streamed this morning, because I don't think we would have known if we didn't watch this, you know? So, okay, now I've yammered on too much. let's keep going.
Thank you. Ms. Cashman.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of my check front and back on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is making a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence when I was Ms. Boone's counsel was the 58-page letter that she wrote. And again, all these letters are published, they're analyzed. I, like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you. Mr. Lake.
Yes, Your Honor, just briefly. But as far as the issue of the $1,800, JAC has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. We just need that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by the statute. The problem is the statute only allows up to 200% of the flat fee in the absence of hourly statements. In other words, the way that the statute is worded very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then it can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each of the attorneys if he's requesting $15,000 each, would be $45,000. As far as, and at that point, looking at the statute, what we have is Ms. Cashman, she got 118 hours in. That would represent at a rate of $75 an hour, $8,850. Based on Mr. Bankowitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours, which would be $15,000. That's the issue, Your Honor, is that
I mean, technically compensation has to be at a rate of $75 an hour for it to go above 30,000. And so beyond that, I mean, ultimately, but we leave it to court discretion to determine reasonable fee for each attorney. And we acknowledge that this, I don't think we can even begin to dispute that this is not an extraordinary unusual case. It's just that what the statute says is how the compensation structure is set up. And we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
That, until you get to double the flat fee, yes, at work, but once you go above double the flat fee, then at that point, it really should be compensation, should be 75 an hour. However, we also acknowledge that we have had other cases like this where the court has awarded the full flat fee to each attorney, and we've never taken it up.
Okay. So I just wanted you guys to see that they're going to be, the order is issued and they end up getting reimbursed for the money. And the thing is, you know, Mr. Lake isn't being like a jerk or anything. You know, he has a boss too, and the JAAC has bosses as well, and those bosses are the taxpayers of Florida. Hi, I'm a taxpayer in Florida. We've all been paying for Sarah's defense, that she is, you know, taking her time and causing all kinds of kerfuffles everywhere she goes. And so it's frustrating as a taxpayer to know how much money in simply just attorneys, just the attorney's fees, they're all going to get reimbursed at 15,000. So what is 15,000 times 3? What is that? 40, what is that? 45,000. Is that right? 15 times 3? It's 5. Carry the 1. 1 times 3 is 3 plus 1 is 4. Yeah. $45,000. And that's just for these 3 attorneys. Okay. Mr. Padilla was also paid, and we're still paying. Now, Mr. Owens is pro bono, so he's not going to be paid, but we are and have been paying for Sarah's private investigator. We will be paying for and have paid for all of the expert witnesses, the different psychologists and psychiatrists that have already come in and evaluated her. And now she is getting a new, a second psychiatrist and a crime scene reconstructionist, you know, and all of this we're paying for. So, yeah, like I'm annoyed about it, very annoyed. And, but I'm not too annoyed to say this. Thank you, Roro, for becoming a member. I appreciate that. Welcome to the ward. And this is another reason, exactly, Jenny. Jenny says, that's why the judge cut her off from court-appointed attorneys. Absolutely. This is exactly why. Because she is just running up a bill, running up a tab on the taxpayer's dime until she gets an attorney in there that will do what she says and when she says to do it. And it's ridiculous. So Bushit says, so she knows what the experts are going to say on the stand before they take the stand. Correct. Well, I don't know if she's going to know everything that they're going to say. I don't know how Mr. Owens and Miss Boone work together. I don't know how they do that, but she has an idea of what's going to be said. Yes. I mean, she was there when she was evaluated, so she knows what she was asked, and she knows what her answers are, or what they were then, you know. So she has an idea of what the experts are going to say. I'm curious about the crime reconstructionist, so I want to know what that one is going to do. All right, so let me get over here to something else. There's something I wanted to read really quickly. Let me see something. All right. Okay. So I'm sure I'm going to have to click this. Let me click this. Yeah, I knew they were going to make me do the test again. Hold on a minute, y'all. I'm sorry. I need to pay attention and like keep a little timer on or something to know how long I can have the page up before they're going to require me to refresh. Very upsetting. Okay, here we go. Oh, also, at the very end of today's live, and I'm not going to do it, make you guys sit through it again, but at the very end of this morning's live, a concerned citizen emailed or wrote a letter to Judge Kranick, and I read that on the live this morning, so you guys might want to check that out. It's at the end. Hold on a minute. Okay, this is where we're at. Okay, perfect. Let me close this one so I don't get confused. All right, so let me stop sharing this. Let me click over here. We read the order. We read that on the 20th. This is just about them being allowed to use prison break. That's fine. All right, let's read this motion. Okay. Let me share the screen. All right. Let me add it. Sorry, you guys. Okay. So this is an order for a motion for court-appointed experts to produce reports. It's not an order, it's a motion. Let's see. Comes now the state of Florida by and through the undersigned assistant state attorney and requests that court-appointed clinical psychologist, Dr. Michael Brannon, and court-appointed crime scene reconstructionist / death investigator, Dr. Michael Berkland, produce reports of their findings prior to trial. 1, the defense filed motions for the appointment of Dr. Michael Brannon and Dr. Michael Berkland on September 18, 2024. The court granted the motion to appoint these doctors on September 19th. The state requested that these doctors provide written reports prior to trial. The defense objects to this request by the state. Neither Dr. Brannon nor Dr. Berkland were listed on the defense's amended witness lists in this case. The state has not previously had an opportunity to depose them. The case at bar is currently set for trial October 7th, 2024. Therefore, the state would request that both Dr. Michael Brannon and Dr. Michael Berkland provide written reports regarding their findings to the state and the defense prior to the close of business on September 26th, 2024. Signed, Dave Cacciatore Jr. Dave Cacciatore Jr. is not playing. And that means this was filed on the 20th, okay, at 3:00 almost in the afternoon. All right. And yeah, he wants to see, and I don't blame him. He wants to see their reports before they go to before they have their final pretrial hearing, which is September 26th. And I do not disagree with that. Okay. Now, the judge has spoken, and we're going to see what he says. Hold on. All right. Let's see what the judge says. Orders on defendant's amended motion to appoint forensic psychologist. The court, blah, 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 orders and adjudged as follows. The defendant's amended motion to appoint forensic psychologist expert is hereby granted. Dr. Julie Harper. And then this is her cost. Okay, we already knew about that. Let me see what else we got. Let me see what this document delivery is. Oh, this is just about the orders from the court. This is about the psychologist again. They're allowed to have the reconstructionist. Okay, close this, close this. Supplemental discovery, let's see. All right. Notice of supplemental discovery comes now. Let me share it with you guys. My bad. I'm sorry. I appreciate you guys being patient and understanding with me as I don't know what I'm doing, honestly. Okay. Notice of supplemental discovery comes now. The state of Florida, by and through the undersigned assistant attorney, hereby makes the following information. Abraham Moreno gave a statement to law enforcement in this case, which has been provided in discovery pages. And see how nice they are? They even give the pages of the discovery number, pages 237 through 247. The undersigned assistant state attorney spoke with Mr. Moreno in advance of trial on September 23rd, 2024. Mr. Moreno indicated to this ASA, that the defendant was stating that what happened was an accident on the day of the murder. Mr. Moreno said that the defendant stated that she was, quote, teaching him a lesson and things got out of hand and that she fell asleep. Mr. Moreno recalls the defendant making this statement prior to law enforcement arriving on the scene. Uh-oh. What do y'all think of that? This is another, this is a witness. I think let me double check and see exactly who Mr. Moreno is in this. I kind of am leaning towards, I think that is who she was pointing at the beginning of the body cam footage, where she's saying, "I want to go talk to the apartment manager." Yeah. Indeed. This is problematic because as we're going to get into more. Okay, so let's see. This is the approved payments. All right. Reasonable attorney. Let's see who they're taking depositions. She has, amended notice of taking depositions, change of locations to James Owens, Kevin T. Beck, Tony Henderson. That's 3 attorneys now. Huh. And where they'll be taking the deposition of Dr. Harper. Now, here's where we want, this is what we're looking for right now. Let's share this. Okay. So we've been talking about this for quite some time, given what took place on, cripes. Why'd I do that? Given what took place at the hearing on the 19th. Right? We've been trying to figure out what is Mr. Owens up to. We all kind of figured he's going to file a motion to suppress. And and what is he trying to suppress? I haven't seen anything about Shelly Beans asks anything on hairstylists and makeup. I haven't seen anything on that just yet, but I'm going in chronological order. So yeah, we'll see if there is. But this is what he is. He's filed a motion to suppress. Now let's find out what exactly he wants suppressed and why he, oh my goodness, I have the hiccups, why he wants it suppressed. Okay. Sorry, you guys. All right. The defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. On or about February 24th, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her superiors and secured the scene. Sometime later, homicide investigators Chelsea Connolly, aka Chelsea Copsel, and Scott Lowen arrived. These two investigators would ultimately be responsible for the homicide investigation and were involved in the interrogation of the defendant at the OCSO the next day. The defendant was ordered to remain on scene while the OCO conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. At some point, the defendant was asked to get into a vehicle with Detective Copel and Detective Lowen. Once inside, Detective Copel recorded the interrogation with the defendant after partially reading her Miranda rights, omitting the final question. The defendant was advised this recorded interrogation was routine protocol, an official procedure for any death investigation. During the investigation, Detective Copel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. After Detective Copel had the defendant's phone for a period of time, she came back and told the defendant that she was taking the phone. Detective Copel asked the defendant to sign a form releasing it to the OCSO for further investigation. The defendant acquiesced to authority and signed the phone. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copel to express her concern that Detective Copel was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed that they were trying to trick her. The detective assured the defendant that they were not trying to trick or implicate her, but the following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained the reason for the change in plans and was because she was pregnant and not feeling well. The next day, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. A custodial interrogation ensued. Immediately after the interrogation, the defendant was arrested and charged with the offense above. This approximate 2-hour interrogation was recorded. The initial dialogue between Detective Copel and the defendant, Sarah Boone. I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am, and I want to ask about these whenever you have a moment, referring to her written notes with questions. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read your rights again because we have to talk about that. Detective, and we're not done talking about the incident. Detective, we just have to do it. Sarah Boone, just like we did yesterday, normal protocol. Detective, just like we did yesterday. Remember, I read you the rights. Detective, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you. Okay. Detective, so you have the right to remain silent. Anything you say may be used in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone, no. And do you understand what I just read you? Sarah Boone, yes. Detective, perfect, okay. Detective, so this morning we went to his autopsy and we were informed of some injuries he had by the doctor. Defendant, where? So he's got a detective. So he's got scratch marks to his back. 16. The interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. The detective read the defendant her Miranda rights directly from a printed card of the OCSO. The detective admitted the final question printed on the standardized Miranda card of the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before. The omitted final Miranda right in question is, having these rights in mind, do you wish to talk to me? The detective has yet to receive the defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office. Upon information and belief, it would look something like this. Miranda warning, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford an attorney or afford a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Waiver. Do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? Based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. OMG. Whew. What do y'all think? You think that do you think that the judge is going to is going to grant this? Give me just 1 second, you guys. Just one second. All right, sorry about that. Okay. I got to say, this is how I am voting. No, absolutely not. Hey, MK, Lil Red, good to see you. Bedtime Bernice, good to see everybody. Thank you guys all for being here. I appreciate it very, very much. I don't know if I'm going to, okay, Neat Noodle. I don't know if okay. Neat Noodle says that she's going to excuse MK's tardiness because she loves him. Well, you might be excusing it, but the high court, me, I don't know how I feel. I don't know if I'm going to excuse MK this time. I just don't know. Although I do adore MK and it's kind of hard to get mad at him. So I'm probably just going to excuse it, but I'm going to talk some smack right before I do it. You're excused, MK. Okay, so here, let's take this one thing at a time. Let me go back over here to look at it. Okay, give me a second. Let me scroll back up. Okay. I don't understand number 5. I mean, I know what it means, but I don't understand the issue. The defendant was ordered to remain on scene while the OCSO conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. Okay. I don't understand what the fuss is regarding that. And I will say that I would never fire you. You can't be fired from a voluntary position, MK Lynn. I would never fire you. I'm not even mad that you're tardy. I just like to give you a hard time because, it's good for you. It's just like you give me a hard time because it's good for me. Makes you tough. I feel like I don't see the issue there. And I do think that a large part of the reason that Sarah was ordered to stick around is due to the fact that things didn't look right. You know what I'm saying? Like here we have, hey, closed reviews, good to see you. How are you? I hope you're doing well. Given the fact that she called 911 and the officer who is responding to the scene is listening to what Sarah is saying, okay, and what happened and what occurred the night before and all the things, okay. She's also talking to Brian Boone, which this is how it started, and this is not related to the crime itself, but it is important, okay. So Brian lets her know that he had to call her multiple times because it was her turn to pick up their son and that Sarah is not reliable. Okay. And that's why he's even over there in the first place. That's how Brian got dragged into all of this, right? In a much deeper way. He would have probably been a witness anyway. That was called by the state, but because he was there, he's a witness in a whole different capacity. He's this is not a character witness. He's an actual witness. And so, and right off the bat, Sarah is not reliable. And then you take that into consideration. Okay. You put that, like, it's one of those things you just, keep in the back of your mind and while you're listening. And then you see the scene. Okay. You see George. From my understanding, he was like half in, half out of the suitcase when the first responders got there. And that doesn't really match up. Having a person, an unresponsive person, half in and half out of a suitcase, I don't think makes CPR very conducive, which again, we all heard that 911 call. I don't think there's anybody who's listened to that believes that Sarah actually was giving George CPR. So some of the details, some things that she can see with her eyes are not really matching up to the things that are coming out of Sarah Boone's mouth. And let's be honest here. Okay. Let's just take the situation at face value. I know that this is Florida. Okay. And that some very strange crimes occur in Florida. There's a whole Florida man. Okay. I get that. But I think this might be the first time I've ever heard about somebody actually dying inside of a suitcase. A body being put in a suitcase is one thing, but dying because you've been put inside of a suitcase, that's a whole other thing. And I'm sure, okay, I don't have that page, KPM. Can you send it to me, babe? Please. I don't have that page. Can you email it to me? Pretty please. Let me know if you need me to put my email here. I'll put it in the chat for you if you can email it to me. All right, there we go. Okay. So, I mean, taking the crime or taking the circumstances at face value, I mean, just the whole scenario, the whole situation is, I'm sure, strange. To hear that Sarah calls it a game of hide and seek when it, and then admitting that she zipped him into the suitcase. I mean, just right there is a red flag. First of all, it's not how you play hide and seek. It's not how it works. You know, I'll tell you what, KPM, I'll go and look at it. And maybe then I don't really like, I don't want to use another creator's, material. I'll just, I'll figure it out. But anyway, but thank you, babe. So I can always just request it myself, but we're probably going to hear about it shortly. So things are not lining up, which is why I think that Sarah was not free to leave the scene, quite frankly. Okay, let me close this. All right, now, actually, you know what, KPM, if you wanted to, if somebody, I mean, I can do it myself, but if somebody would be a lamb and send me the link to the audio from that interview from inside the car with the detectives, I would like to hear it, because I would really like to match up what Owens says is said versus what was actually said. Now, moving down to the investigation, to the actual interrogation video. I have been working on a video, but I got to tell you guys, I'm not into it. You know what's been going on. I'm just distracted, and it's just, I don't have it in me to do. I'm sorry. So I'm just going to talk about what I was going to talk about in the video right here. Okay. I went back and I extracted the audio from right before they walked through the door to the interrogation video. Okay. Or to the interrogation room. You can hear them, but it's not that clear. So what I did was I extracted the audio, I uploaded it to Audacity, I enhanced the voice, I slowed it down, I removed background noise. And what I hear the female detective say to Sarah is, I'm just going to have you sit over there. Or no, that's after. She says, if you need anything or more water, please just let us know. And then they're coming into the interrogation room, and she says, I'm going to have you sit in that chair over there. And she does say that they got some preliminary, some results from George's autopsy, and he had some injuries that she wanted to talk to Sarah about. Okay. And Sarah does make that comment with her list. Okay. But first of all, her rights were not violated. Okay. I don't know that you have to, in the state of Florida or by the Constitution. I mean, she already agreed that nobody made any threats or promises to get her to talk to get her to talk. And so I feel like I don't think that I don't think that her interrogation video is going to be suppressed. Okay. Period. Because not only, and then another claim that he doesn't make in his motion, but he did make in that hearing, was that Sarah wanted them to look through her phone. They did. look through her phone. Hello? But then later, she's talking about, she was documenting things that George had allegedly done to her, right? And she remembers, oh, wait, they're not on the phone, they're on a laptop. So if he actually listened and watched that interrogation video, it's his client. Sarah's not my client. I don't have a dog in this fight. I would like to see justice for George. That's what I would like to see. But I mean, my reputation isn't on the line here if Sarah's found guilty or if she's acquitted. If she's acquitted, I'll be disappointed in the justice system. I'll accept it, but I'll be disappointed. I don't have a dog in this fight like Mr. Owens does. And if he would have watched that interrogation video, and paid attention to it instead of clearly skimming through it, then he would know that those photographs that she's referring to are not on the phone. They're on a laptop. What's going on with little Red? What's going on, little Red? Who's not feeling good, babe? And this right here. At no point did Monica says, at no point did Sarah say, I thought I was coming down here to get my phone back, or you told me to come down to get my phone. No, because she knows she's coming down there to talk. And that exactly. Boom. That's it. That's all. No, but seriously, what's going on with little Red? How am I not, I don't understand what's going on. What's going on? Is your doggy okay? Little Red? I hope so. KPM says that's gaslighting her lawyer by telling him she was tricked. I think gaslighting is a kind word for it. Honestly, I'm going to tell you exactly what I think. And I'm just going to tell anybody who's on replay or who's new to the chat. I lost my sweet Nestor on Sunday, and I have a very low tolerance for BS right now. And so the things that are the words that are coming from Owen's fingertips in this motion have gone all over me. I'm annoyed with it. I think it's ridiculous. I think that it is putting the victim on trial, and I am not for that. This is not a case of self-defense. This is not a case of, I feared for my life or any of that. It's ridiculous. And they're going to try to bring all kinds of stuff in, and it's ridiculous. It pisses me off. She lied to her lawyer. That is not what happened. And there's absolutely no way to prove. Let me see. My dog is going to a specialist to see. Oh, no. I'm sorry, Little Red. I'm sorry, babe. Well, I'm sorry. We do. We need a day. We need a good trial to concentrate on and harness all of this. We do. I'm so sorry, babe. I'm so sorry, Little Red. Babe, that's so hard. We'll be there for each other. So yeah, I just feel like this is, I know this is not a legal term, but I'm not an attorney, so it doesn't matter. But at the end of the day, this is total and complete, utter poppycock. Okay. What this, what Sarah's trying to pull, and through by extension, her attorney. Again, he should have listened to that 2-hour interrogation. I know why he's trying to get it thrown out, because he is intent on using this battered spouse defense, and he thinks this is his best shot at getting her. I don't know what he's hoping for. I really don't. I don't know, because I don't know that we haven't gotten to the part where there's the jury instructions yet. So I don't know if there's going to be an option for lesser included charges, or if the state is saying we're going murder too, that's it. We're going second degree murder, that's it, that's all. She's either guilty of second degree murder or she's being acquitted. I don't know what they're going to do, but I think that Lil Red, I've read all of it. And I've read all of it. This is now the second time that I'm reading it, and there's no validity to this. There's absolutely no validity to this. So this is why he wants it thrown out, because all throughout that, and the total time is 1 hour, 55 minutes, and I think 49 seconds is what the total of the interrogation video is. And all throughout the interrogation video, first of all, she starts out with, it was a good day. Nobody got out of sorts with each other. Nobody was physical with each other. They weren't arguing. They were not fighting. George left and went to, even for a minute, to go to Publix. He walked to Publix and he walked back. So there was space between them. They were having a good time. He danced with the dogs. There was arts and crafts. You guys remember the interrogation video, all the things. Okay. Then she goes on to say that everything after that was an accident, that there was no malicious. Let me just put it for you. Nobody can say it like Sarah. So here you go.
No malicious.
There was no malicious intent behind her zipping him in the suitcase, that she left a gap. She didn't fully zip it, that there was enough for him to get 2 fingers out and he could unzip it himself and get out. And that's what she thought. And then she went upstairs and did all the things that most people do before going to bed, including getting in the bed, putting the covers over her, laying down. It's not like did you wake up sitting up, Boone? No, you were laying down. Stop playing with these people out here. And accidentally went to sleep. Accidentally. So come on, give me a break. I'm over it, Boone. And that's why he wants this. That's why he needs to get the interrogation taken out. Because if he gets, you can't argue battered spouse defense while you're up there on the stand talking about, it was an accident. Self-defense is not an accident. What am I doing? Going to get the autopsy report. That's what I'm doing. What am I doing? I don't even know how to type, apparently. Bruh. Here we go. Sorry, you guys. All right. So I think that this motion has 0 legs. I think it's going to not be granted. I think the interrogation comes in, and this too, on top of everything else that she did that day or that evening, she has the bright idea to videotape herself. Well, record herself. It's not really videotaping. You can tell what generation I'm from. But record herself taunting him, because that's exactly what she was doing. And I don't give a rat's fat kneecap what that psychiatrist gets up on that stand to say. I'll listen to it. I'll take it in. But I cannot imagine that psychiatrist is going to get up there and testify for Boone and say anything that's going to make me forget what I saw in that suitcase video. And that is her taunting him. And that was malicious. That was all the malicious. And thank you, Chicken Shite. No one said malicious. She did. It's her word hearing those videos during the interrogations. Amen. No malicious. Yeah. That's on you. Bruh, I can't. What's going on with May's mom? Oh, you got a sick doggy too, May's mom? What's it? What's going on with the dogs? What's happening? Yes, it was very malicious. It was all the malicious's. Completely malicious. Ugh, she makes me so annoyed. So annoyed. Okay, I don't need this window open. All right, so let's see what other interesting oh, there's an order denying something. Let's see. Order on state's motion for court-appointed experts to produce reports. It's denied. Huh. It doesn't say why. Interesting. So they don't have to produce reports. Huh. That's all there is until the 26th. All right, so let me stop sharing this tab. Let me open this up. All right. And let me close all this out. Wonder why he's denying that with no, huh. Is that who he is, Peter? Okay, thank you. Yes, I did read earlier the statement given by I didn't realize that it was I didn't realize that's who that was. I thought it might be the apartment manager or, one of the people in the apartment office because she was wanting to talk to, and she said, "Can I go talk to him?" And so I was thinking maybe that's who that was. But let me look at this one last time before we go on to the autopsy report, because this is the supplemental. Hold on, let me see what this is. This is about I don't need to see this. This is about where the depositions are going to be and the supplemental discovery. What is this? BWC videos from Orange County case. Wonder what that is. Some video. All right. And that was filed today. Where's the other one? The supplemental discovery. Mr. Moreno. Is that who you're talking about, Anthony? Oh. I feel like we did hear that before. Huh. Oh, little Red, you didn't have to do that. Thank you. With malicious intent, Boone the Loon needs a long prison sentence. Thank you, babe. I appreciate that. You didn't have to do that. Thank you. Thank you so much. That was very generous. Thank you. I appreciate that. I feel like we heard from Mr. Moreno, like his actual audio. Well, listen, okay, this was my plan, you guys. All right, so today is the 24th. The final hearing before trial is the 26th of September. And I was thinking that we need to do like a Boone-a-thon before the trial, but I wasn't sure like how soon, like how to do it. Like, should we do it after the hearing on the 26th. Obviously, that's going to be important. I'm going to stream that on Thursday morning, but like a whole weekend of Boone, because remember, Allie and I are also waiting on calls. So I am sorry, Bushi. Yes, I'm going over that right now. But that's what I was going to do, is do a Boonathon. So what I'll do is I'm going to gather up some stuff for us to look at. And we're just going to go over all of the things pertaining to Sarah Boone. All right, Natasha, I love that, Natasha, that Bushi keeps me on task. It's important because I've been getting off into the weeds. All right, so let's read this autopsy. All right, final anatomic diagnosis. So his cause of death was listed as positional asphyxiation. Oh my God, geez, Jen. Positional asphyxia with environmental suffocation. Final anatomic diagnosis. 1. Positional asphyxiation with environmental suffocation. A 42-year-old man within closed suitcase. B. Prolonged confinement. Blunt impact injuries to torso. Cutaneous contusions. Deep muscle contusions. Cutaneous abrasions. Periorbital edema and oh gosh, I know how to say this. Ischemiosis. Left eye. Galeal and subgaleal hemorrhage, intoxication by ethyl alcohol, toxicology, see analysis, conclusion, consideration of the circumstances surrounding the death, and after the examination of the body and review of the toxicology report. It is my opinion that Jose Torres Jr., a 42-year-old man, died as a result of positional asphyxia with environmental suffocation. The manner of death is classified as homicide. Now, let's see. The body is that of a well-developed and nourished adult man compatible with the above stated age. At the time of the exam, the body measures 62 inches in length and weighs 103 pounds. Body mass index is 19. The body is ambient temperature. Rigor mortis has receded. The livor mortis is fixed posterior and rises to the level of the posterior axillary lines. Fixed lividity also involves the left side of the torso and left upper extremity. In the lateral aspects, the body is neither decomposed nor embalmed. So if the fixed lividity is on the left side, then that means that he was laying on his left side. Let's see. His mouth has no, there's no petechial hemorrhaging or anything like that, and there's free of foreign materials. His neck is symmetrical and has no palpable masses. The abdomen is normal. Everything else, his genitalia is normal. These are all his let's see. These are his tattoos. Per investigative reports, the decedent had climbed into a suitcase which was subsequently zippered closed. He remained in the suitcase for up to 11 hours or more per reports. Additionally, review of cellular phone data recording revealed the decedent stating that he was not able to breathe while in the suitcase. These are his blunt impact injuries, and this is what they were talking to Sarah about. You guys doing okay in the chat? Okay. All right. The lateral aspect of the upper eyelid has dark purple. Am I saying this right? Eschimosis, and is associated with a small amount of subcutaneous edema, which is swelling. The mucosal surface of the lower lip has a few contusions and lacerations. The left temporal parietal region of the scalp has galeal and subgaleal hemorrhage estimated at less than 20 cc's. The right side of the face near the corner of the mouth has a crescent-shaped red-purple abrasion. The right side of the neck in the supraclavicular region has a few scattered red-brown linear abrasions on his neck. The mid-upper back has a series of obliquely oriented linear abrasions, each with a width of 0.3 centimeters and lengths of 7, 12, 15, and 6 centimeters left to right, respectively. The left side of the neck near the posterior axillary fold and extending medially is a series of punctate purple-blue contusions. The above described contusions involve the underlying adipose tissue and skeletal muscle and are associated with intramuscular edema. The sacral area of the back at the posterior midline has a 8 by 6 centimeter zone of red purple ecchymosis. The dorsum of the left hand has purple blue. I'm going to look this up. Ecchymosis overlaying the metacarpals and second digit. The dorsal aspect of the right hand has faint red purple ecchymosis overlying the metatarsal area near the base and thumb. The posterior aspect of the right arm near the elbow joint has a 4.5 by 4 centimeter compressed dry red abrasion. The lateral aspect of the arm has 2 vertically oriented red-brown linear abrasions measuring 3 centimeters and 8 centimeters in length, medial to lateral, respectively. Let me look at this. Where's that one thing that I wanted to say? This right side of the face near the corner of the mouth has a crescent-shaped red-purple abrasion. To me, I feel like that is indicative of like your fingernails. Usually when somebody claws at somebody, like makes the marks are crescent shaped. Fingernail marks are usually crescent shape. To me, what it sounds like is I'm interested at the neck, because if this were a situation where he had something around his neck, of course, people will claw, obviously, to get that out from around their neck if their hands are free, right? But that's not what happened in this case. There's nothing. His neck is unremarkable aside from scratches, and we do know from the past incidents between the two of them that Sarah has, and between Sarah and Brian Boone, that Sarah has a history of clawing at the man's neck. That's her deal. To me, what it sounds like is that, to me, I think it's indicative of exactly what the neighbors testified to, which was George being zipped in that suitcase and going down those stairs. That's what I think. It's also entirely possible. And I think that because not just because of the bruises, but okay, everybody, like, close your eyes, okay, and picture your suitcase, okay, when you pack it, all right? You zip it up, you close it, then you stand it upright usually, and it has wheels, and you wheel it, right? And then you turn it over. You go to the airport, you turn it over to the porter. They put it on the thing and you check your bag, all the things, right? And then when you arrive at your destination at the luggage carousel, you go to pick your items up and your suitcase is laying flat. You pick it up, blah, 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 right? And we all know that when we get to our destination and open our suitcase, things are jostled around. They're not exactly how we left them. So what I think that some of the abrasions that they're describing are a result of when he is inside of the suitcase tumbling down, the friction between the weight of his body going down the stairs and rubbing against the inside of the suitcase, because it's not smooth inside of a suitcase. It's canvasy, right, on the outside. But then there's also like where the zipper comes together, and also like if it has the little straps that you can, like, I never use those because they never do anything but mess up my clothes more. It's like they seem to come out better if they're allowed to get tousled a little bit. But anyway, but there's like vinyl inside of it too. And so, okay, so Roro says, is there any possibility that he got into the suitcase upstairs, then was pushed down the stairs while he was in the suitcase? That's what I think happened. I don't think for a second that suitcase was ever down the stairs. That's not where it started out. I don't know how the conversation between the two of them occurred where George got into the suitcase, but I do think that there's a strong possibility that that is true, that he did get into that suitcase. And I think that Sarah zipped it up. And I do think that she pushed it to the top of those stairs and then she pushed it down the stairs. And I think that is where the abrasions come in. That's where the bruises come in. And I think that explains how I think that explains how the suitcase ended up upside down in the first place, right? And I think what Sarah is saying in her interrogation interview when she's talking about flipping it, she did a couple of times because it's in one position, which is with the flap down in one video, and then it's the correct way up. But without further details, and then obviously he wasn't able to get out of it. And I kind of am wondering if he had been flipped right side up, if he would have been able to get out of it, or if Sarah's telling the truth and she left like a place for him to move, to stick his fingers in to try to get the broken suitcase zipper thingy, handle holder, whatever you call that thing. Because it didn't have that piece to it. It was just the top, it's just the actual zipper part. And if he was able, I wonder if it was right side up, if he would have been able to get out of it, if Sarah had left that like she said she did, or did she zip it all the way up and he wasn't able to get out of it? Or the third possibility is it a combination of both? Yes, she did leave that hole, right? But she also flipped the suitcase again. I suppose Jeffries asks are those injuries from him suffering violently to escape the suitcase? I would imagine some of those injuries might be from him trying to get out of the suitcase. See, there is, Mr. Owens wasn't wrong in something that he said. And my theory is people leak and it's unintentional. And I think when he got up in front of the judge on the 19th and said a lot of things happened before and after that video, those videos from her phone, I think he's telling the truth. I do think this is what we don't know. We don't know how long, for the truth of the matter, because Sarah says one thing and it just doesn't make sense. But we don't know how long after that second video stopped, right? Because that's the quick one. It's only a few seconds long. We don't know how long between that stopping, right, and her going upstairs and accidentally on purpose making all of the preparations to go to bed and fall asleep, but yet somehow accidentally go to sleep. How we don't know how long in between that, how long in between that of the time that was. We don't know. Um, so, and the other thing is, this is why I do think that it's a strong possibility that George got into the suitcase willingly. Because, okay, let's say, for example, this has been theorized that George was unconscious and put in that suitcase. Just moving another person while they're unconscious and you are highly intoxicated, which Sarah was, you would expect that there would be, it's not easy to wrangle somebody who's still alive but unconscious into a suitcase. I would expect that there would be, some marks on her. Okay. We know that he didn't get into that suitcase during a fight, right? Because there's nothing on Sarah. She's photographed. She has no injuries. So she's being honest. There wasn't an argument or a fight that day. And it surely wasn't uh, physical. And I don't either, Lil Red. I don't think that she could lift him or maneuver him into that suitcase. Absolutely not. So I think that I think that there's truth to that statement, that he did get in the suitcase voluntarily. Why he was thinking that, I would say, Natasha, she weighs probably close to what George weighs, if maybe a little bit more. Maybe I would put her between 105 and 110. That's what I think, how much she weighs. And she did say on the 911 call that she put him in there. And here's where the problem with that is, Jeffrey, she only said it once. She only said, I put him in the suitcase one time. All the other versions of the story have been, he got into the suitcase, I zipped him up. And so I think that for prosecutors, it's not about what you know, it's about what you can prove. And I don't think that there's conclusive evidence one way or the other, truthfully, about the circumstances under which George got into that suitcase. And I think without any witnesses or anything, I think it would be really difficult, because it's not as if, like, when he had his autopsy, it confirms that he died in the suitcase. He wasn't placed in the suitcase after death, right? So I think that that would be something that's very, very difficult to prove. And so I think that more than likely, what had happened was he got in there. And, Jeffrey says she got him in there with with the guise of hiding him from the cops for a no contact order. I mean, but why would the cops be there in the first place? They weren't arguing, they weren't fighting. And I think without knowing, I guess what I could do is FOIA request the calls for service to that address. But I'm going to have to go back and listen to the neighbor again, because the way that I remember it, Jeffrey, is that he talked about other incidents before with them fighting. And I don't recall if he said that they were fighting that day. What stood out to me about what he said, and it's been a minute, so I'll go back and listen to it. This will be part of our Boonathon. But what stood out to me about what he said is the loud noise going down the stairs. So I'm gonna have to let's go listen to it. Let's go listen to it. We have time. All right, we will listen to it because you're probably right. I mean, hold on. Well, first of all, that's not how you spell neighbor. I don't know why the suggestion was a different, was the British spelling of it. Hold on, let me find it. All right, here we go. All right, so I'm going to share the screen and we're going to play this video from Mentor Lawyer. You guys go check him out. I'm going to put the link in the chat. I really adore Mentor Lawyer. I think he's, the work that he has done on this case and the Adelson case is just impeccable. He explains things really well. So if you've been following the murder of Dan Markell and the case against the Adelson family, and you really want some really good insight into that case, I would highly recommend following Mentor Lawyer. He is fantastic. Let me put this link in the not this link. This link. All right. And then let me mute this really quick. And we'll play it really quick until it gets to the
-017904. I'm currently located at 4748 France Lane, apartment. France Court? Are you sure?
That's what I always park up. Yeah, because you can see it on the sign over there on the 4749. It's France
Okay,
Court.
France Court.
Yeah, it's weird. For some reason, all of the signs are on the opposites, are on the wrong side.
On the
of
wrong,
building.
yeah, the
So
further
that's
side.
apartment 8 there, and the sign's right there on that one.
Gotcha.
Hey, just really quick, we're going to listen to this and I'm not going to interrupt after this point, but I need a drink, so I'll be right back.
Okay. France Court. Apartment, the Tealwood Parks apartment. And I'm speaking with, can you state your name?
It's Brandon Knights.
And your date of... Okay. And you reside at this apartment, is that correct?
Yes, ma'am.
Okay. And you said that you've been living here since January of 2019?
Yes, ma'am.
Okay. On Sunday, which would have been...
The 24th?
Let's just double check. Sunday was the 23rd.
23rd.
Were you home that day?
I would have come home a little late that evening, but I would have been here around 8, 9 o'clock. I would have gotten in around 8 or 9 o'clock.
PM.
Yes.
Okay. And so your apartment is right next to apartment number 3. Does your apartment share walls with theirs?
My bedroom shares a wall with the lower half of their apartment.
The lower half. Okay. Do you recall hearing anything coming from apartment 3 while you were, after you had gotten home?
Around 10:30 or 11 o'clock, there was a very loud crashing sound where I believe, I'm not sure, I haven't been in their apartment like my roommate, but I believe is the location of the staircase.
Okay,
so
so
a little bit
a very loud, you said crashing sound?
Yeah, like it sounded like something had been like falling down the stairs. Because it started up high and then it ended low.
Okay. And when you heard the loud crashing sound, did you hear any voices? Like, could you make out if you heard a male or female's voice?
I couldn't hear anything, no.
Okay. Is that normal for you to hear noises coming from their apartment?
Not loud, but
Not that loud?
Not that loud.
Okay.
But I'll regularly hear like thudding sounds, like stuff being like slammed against the wall or something like that.
Okay. Have you ever heard voices? Have you ever been able to determine?
I've always kind of like tuned out if I was hearing voices.
If you heard something,
yeah.
you okay. But you have heard loud noises in the past, but not as loud as you had heard on Sunday night.
No, it'd never been that. Like I felt the walls shake.
Okay.
As the sound happened.
And do you know either of them? Like, do you know?
I've had a few brief interactions with them.
Okay.
But I don't.
Like, do you know who lives there? Like,
yes.
Can you describe who lives there for me?
It is a sort of, I guess, like middle age. I don't know, like around 40s, blonde woman.
Okay.
And a Hispanic gentleman. I believe so. I haven't interacted with him much. I've spoken to her a few times.
You've spoken to her a few times. Okay. Anyone else live there?
I believe they have a little boy.
A small child. Okay. Okay. When you have seen them around, how do they appear to you?
They almost always seem either like tired or like tweaked out.
Tweaked out?
Yeah.
Okay. The conversations you had, the interactions you've had with the female, like, what do you mean interactions?
I remember one night she slept on the back porch of my apartment for some reason. I don't remember much, but I just remember like looking out the shade and seeing her like laid down.
Okay. Do you recall like maybe what month this was?
I couldn't say. It was pretty early when I moved in. I would say the summer of 2019.
Summer of 2019. Okay. Did you wake her or?
No, I just.
Okay. And by sleeping, you guys all have like a cement area, right?
Yes.
Like a back patio,
Yes.
but it's not enclosed.
No.
Was she in a chair on the ground
Like
or
on the ground.
on the ground? Okay.
I don't have any chairs on our back porch.
Okay. Any other run-ins with her? Things you've witnessed with her?
I was coming home from class one night. I would not be able to give you a time period on this.
Sure,
I don't
yeah.
remember when it is. And I was waiting on my roommate to get home because I had left my keys in the apartment.
Mm-hmm.
And I remember she came over and was talking to me for a minute, and it was very visible that like she was talking to me because she didn't want to be in her apartment.
Okay.
I don't know why, like I didn't ask, but it was just very evident that she didn't want to be there.
Do you remember anything she was saying?
No.
Her demeanor?
She seemed like skittish, like nervous.
Okay.
I don't remember anything we talked about because, in complete honesty, when I was just, it was in one ear and out the other.
Right, yeah, you were just kind of, right.
With vague nothing.
Okay. Did she appear to be on anything at that point, or just she seemed nervous?
She seemed nervous.
Okay.
She didn't seem like high or anything. She just seemed out of it.
Okay.
I would chalk it up to be more like tired and paranoid or nervous, stuff like that.
Okay. And any other interactions with her?
No. Honestly, from the few times I had spoken to her, like anytime I saw her, I kind of just tried to go straight into my apartment.
Right.
There's a few times where I would walk past and she'd say hi or something, and I was just kind of lie and be like, oh, I'm only going to be here for like 10 minutes. I just got to change and head back to class or something. Like I try to avoid.
Okay. Did you ever witness either of them on their back porch patio?
No, I don't walk that direction.
Okay.
I don't have any reason to go like that.
Right. You guys don't have any like dogs or anything that you have to
I don't have
walk?
any pets.
There you go. Okay. Any interactions with the Hispanic male?
No, not that I can recall.
No. Okay. Okay. Is there anything else that you think is important for me to know about them and anything you've heard or witnessed between the two of them?
It seems like an abusive relationship. Just from every time I heard them, every time like I saw the two of them, it seemed rough.
Okay. Okay.
It's one of those things where like he was a bad guy. He was a bad guy.
Mm-hmm.
Okay, so there we have it. Oh, okay. AKA the cat lady. I'll check it out to see. I mean, because I feel like I'm curious about Brandon and if the state has been able to find him or not. And I can understand from this last sentence that he just said that that George was a bad guy, why the defense is looking for him. However, they can say, at the end of the day, that might be his experience with George, right? And I'm not going to take that away. People have their own experiences with people. And that's the way that it is. Oh, you're going home tomorrow. Yay, Shelly Beans. If you're supposed to be going to sleep, you better go make Mimi's right now, ma'am. And I think that if he were to get up on the stand, right? Let's just explore this. Let's say that he's located, okay? And he is called not by the state, but by the defense, okay? The state has this interrogation audio, okay? So what they're going to do is then they're going to introduce this interrogation video or audio, excuse me, into evidence to impeach his testimony, as in not to impeach it in a way where to completely discredit him, but to also remind the jury and Brandon of what he said occurred on the night in question, which was that there was no argument. He didn't hear an argument. What he heard was something going down the stairs so loudly that it shook the walls. And so that's going to be a problem for the defense. So again, Mr. Owens, like you say that you watch YouTube, okay? And if you just happen to somehow, some way through the algorithm come across my videos, particularly these last few lives that I've done where I address you directly, you should probably, maybe Brandon is not the witness you want, because while Brandon may be able to testify to the toxic relationship that was between George and that existed between George and Sarah, which, by the way, is not in dispute. Nobody is disputing that. Not even the state. They understand. I mean, this occurred in the same county and city where George was prosecuted for domestic violence. This is not going to be a shock to the state. but maybe you ought to watch all of this, because maybe you don't want Brandon as your witness, because he might be able to testify about the toxicity and maybe his impressions of George and that he was a bad dude. But he's also going to be asked about what he heard that night. And the fact of the matter is, he heard a loud boom going down those stairs and no fights. And he was used to fighting. So there you have it. That might not be a good idea. Maybe you don't want to find Brandon. But here's my bigger question. Let's move on from that. With respect to he potentially being homeless. I'm curious if the state has already deposed him, and if the state is able to locate him, and if the answer to either one of those, both of those, is yes, if the state might not be calling. Well, obviously, if the defense is looking for him, it makes me wonder, like, when is the last time they were in contact, the state, with Brandon, or where they knew his location? Because I'm curious about this. But yeah, I find that very, very interesting. And the fact that there was, and let's go back all the way to the beginning, and let's just make sure I heard that correctly. And see if there was arguing. All right.
And you said that you've been living here since January of 2019?
Yes, ma'am.
Okay. On Sunday, which would have been,
The 4th,
let's just double check. Sunday was the 23rd.
23rd.
Were you home that day?
I would have come home a little late that evening, but I would have been here around 8, 9 o'clock. I would have gotten in around 8 or 9 o'clock.
PM.
Yes.
Okay. And so your apartment is right next to
Good night, I'm Kayleen. Thanks for coming. I appreciate you.
apartment number 3. Does your apartment share walls with theirs?
My bedroom shares a wall with their.
Good night, Coolest Reviews. Thanks for coming. It was good to have you. It was good seeing you again.
The lower half of their apartment.
The lower half. Okay. Do you recall hearing anything coming from apartment 3 while you were after you had gotten home?
Around 10:30 or 11 o'clock, there was a very loud crashing sound where I believe, I'm not sure, I haven't been in their apartment like my roommate, but I believe is the location of the staircase.
Okay,
So
so
a little bit above.
a very loud, you said crashing sound?
Yeah, like it sounded like something had been like falling down the stairs. Because it started up high and then it ended low.
Okay. And when you heard the loud crashing sound, did you hear any voices? Like, could you make out if you heard a male or female's voice?
I couldn't hear anything, no.
Okay. Is that normal for you to hear noises coming from their apartment?
Not loud, but
Not that loud?
Not that loud.
Okay.
But
Okay, so Jeffrey, you're saying that it was Vincent that heard the yelling, "I hate you." Okay, I'll have to go and try to find that interview. But I'm curious how Vincent heard the yelling, "I hate you," but Brandon didn't. So now I'm going to have to look into that and try to find that interview, because this is the only one that I remember. That doesn't mean that's the only one there is. It just means that, I'm it's the only one I remember. And Peter says, Jen Lou, Brian's testimony would be the same way. It's a double-edged sword, because he can testify to George hurting Sarah, but he can also testify to Sarah hurting him. And that's true. See, this is like this whole case and the situation and the relationship and everything that existed between George and Sarah. I mean, people are multifaceted, and they're not all things all the time. They're different things at different times. You know what I mean? And so, and there's layers to this scenario and this situation. And I think that anybody really that would get up there to testify, including like George's parents, they're going to probably have George's family up there because they're witnesses to the relationship that existed between George and Sarah. And also they are George's family. And so the state likes to give the victim, they like for the jury to get to know who the victim is. Okay. Because they're more than just a victim of this crime. George is, a son, a brother, and a father. And at one, so he was loved by his family. And so they're going to want to do that. But, again, anybody that would testify really that knew the couple is going to testify pretty much to the same thing. This is what I don't understand. Okay. Sarah said 11 billion times in her statements, all of them, the one from the body cam, the audio from the detective's car, the actual interrogation video, that she did not intend for George to die and that it was an accident that he died. Okay. I don't understand why Owens doesn't say, ladies and gentlemen of the jury, what happened was unintentional. She didn't intend for him to die. And perhaps if she had been in her right mind, i.e. sober, not drunker than Cooter Brown with a Xanny mixed in, maybe she would have taken the situation and him saying that he couldn't breathe more seriously. And it's my opinion, not mine, but I'm speaking as Mr. Owens. I don't even know if this is a legal argument that can be made, but I would argue that she's not guilty of second-degree murder. She's more, she's guilty of maybe manslaughter, something like that. That's what I don't understand, why he is trying to use the battered spouse defense, which really relies heavily on, I think that it's been established that there was domestic violence that existed between the two of them. However, unlike most battered spouse syndrome, people who have battered spouse syndrome, they are usually not the aggressor in the situation. And it's interesting to me that Sarah, was probably as much of the aggressor. I think it was equal. She was the aggressor as many times as she was the victim. And thank you, Neat Noodle, for the membership, babe. If you're the one that got the gifted membership from Neat Noodle, please be sure to thank her. But I feel like using the battered spouse defense, and it's a very dicey proposition because a lot of it is going to hinge on whether or not, first of all, the first hill that he's going to have to climb and get past is whether they let the interrogation video in and the audio from the recorded interview. If they let those come in, both of them, it's out the window. If the judge decides the interrogation video is out, but the audio is in, it's essentially the same thing. The audio is the exact same thing. What will be missing if the interrogation video doesn't come in would be Sarah's face when she saw the videos. And then I just don't so he's got to get over that. Okay. And then he's got to get past those videos that Sarah took. And they're awful. I mean, we've all seen it. We've all, we don't need to go over it, again and again. but I feel like I just don't see why that how he came to the conclusion that this is the best defense for her. Like this is the best and only defense for her. I don't see it. I just think I don't know. I'm not an attorney. So I can't, it just seems to me like this is a bad idea. Just an absolutely awful idea at a defense. And I cannot figure out what is going through um why Owens thinks that this is it. And I will say this, KD. KD says, God, no, those videos mess with me. They're horrible. Um, I have played the videos on my channel, I think maybe once or twice. I definitely know that I've played them, in a because they're part of the interrogation video, and I've roasted Sarah's interrogation more than one time. And so they were played, but I don't like, as much as I talk about this case and as much as those recordings are integral to the case itself. I think everybody, if you want to go find them, you can find them. I've played them enough. You know what I mean? I just feel like I don't want to do it anymore. It's hard. It's hard for me and it's hard for you guys. It's awful. I mean, the more they're just awful. I don't need to belabor the point. I just think that, I don't understand what's going through Owen's mind that the battered spouse defense is going to be overcome the contents of those videos, because they don't show somebody in fear. What they show is somebody taunting. The victim is the person that's in fear. And this is a suitcase that she used. Then you have the fact that there are no marks on Sarah. So where was he where was the imminent threat? Where was the threat of imminent danger that required Sarah to somehow or another? This is where the whole scenario doesn't make sense. Like, let's think this out, okay? There's no argument going on, right? But you're in fear of this person, and somehow you convince the person to get in the suitcase. So it just, the whole dynamic of it, the whole everything doesn't make any sense to put what happened that night into the early hours of the next day, to put those facts and circumstances and try to make it fit the battered spouse defense. It feels like putting a round peg in a square hole. It's just not going to fit. Like, it doesn't logically make any sense. And I feel like this isn't, Natasha says, playing the only card they've got kind of a thing, I suppose. I feel like, why can't they go for unintentional homicide? And this is another thing. NWAW Skeptic says, the way Owens wants to redefine BSS to mean the person doesn't even have to be in real danger, but just imagine they are, is infuriating. And see, it's these situations, it's these cases like Sarah Boone, like Letitia Stout, where they take things that are true, that there are actual victims of abuse that is so horrible, so egregious, that their mind splits into and fractures into different personalities, and thus results in dissociative identity disorder. There are people that does happen to. Okay, that there are people that believe it's not a real diagnosis. I personally do believe that it is a real diagnosis. So you're taking that, okay, and here comes Letitia, and then you listen to the interview that she gave to Dr. Lewis, where she is, pretending to be Maria Sanchez, and saying all of the things, and Maria is the one that actually shot Gannon. It's ridiculous, and it's an insult to real victims who suffer from dissociative identity disorder. And now we have Sarah Boone, okay, where now we have Sarah Boone, where is Sarah Boone a victim of domestic violence? Yes. Is Sarah Boone also the perpetrator of domestic violence? Again, the answer is yes. Okay. So she is both the victim and the perpetrator. However, I don't believe that she fits the criteria for having battered spouse syndrome. Many of the traits and characteristics that you see in victims of battered spouse syndrome, Sarah does not exhibit. She does not think that her abuser is, all knowing. She doesn't take responsibility for the abuse, meaning she doesn't say, if I would have had dinner ready at 5:00 instead of 5:01, it wouldn't have happened. It's my fault. If I would just do this or not do that, this wouldn't have happened. It's my fault. In fact, it's the complete opposite of that. Sarah takes literally zero accountability. And she also is the hero in this relationship, according to her. She is the one who takes care of George. She does everything for George. She said it in her interrogation video. I'm still taking care of George. That, in my opinion, is not does not make a battered spouse. It does not make Sarah the victim. So, how do I put this? I don't think that Sarah has battered spouse syndrome. I think that the truth of the matter is this. I think that separately, George and Sarah are people with issues. And they would have probably had the issues that they had whether they were together or not, okay? Because they were drinking for a reason. However, something about the two of them and their own individual brand of dysfunction when they came together, similar to gas and fire, created an explosion of dysfunction and toxicity that existed between the two of them. But I don't think that, let's even look at the power dynamic that existed between them. I've talked about this ad nauseum. It was Sarah's apartment. Sarah was on the lease. In fact, the last time that George had been arrested for domestic violence was at the end of 2019. And I don't recall if he had a no contact order in 2019, but I know he had one in 2018. And excuse me, at the end of the day, he didn't even have a phone. He wasn't working. The apartment was Sarah's. The money they lived off of was Sarah's. The phone was Sarah's. It was, she didn't just have a lock screen on her phone that you have to type a number code in. She had a, excuse me, hold on a second. She had it set to facial recognition, for Pete's sake. So anytime and every time George ever wanted to use the phone, he had to take it to Sarah. And then on top of that phone has a record of everybody he ever spoke to. And if they texted, there's a record of the text. Sarah was running the show. And I agree with this too, NWAW's psychic. I do believe her in that it wasn't a pre-orchestrated scheme. It was an impulsive murder of opportunity. Once he was in there and suffering, she took advantage of it. I agree with that. I don't think that Sarah had been biding her time in an effort to to kill him, okay, to murder him. I think this was a crime of opportunity. I think that the type of drinker that Sarah is, we all know somebody like this who, when they drink, there's a limit up until a certain number of drinks, and it's different for each person. They're fine. There's nothing they're having a good time. They're just drinking whatever. But then there's that drink that causes the switch to flip, and they are no longer having fun. They are like they're at some people get emotional when they drink and they're crying and they want to be sad and all that. Then there are people who a switch gets flipped and they become confrontational and violent and argumentative, etc. And I think that Sarah was the latter. And I think that at some point she and George were upstairs doing God knows what, doing whatever, and the conversation switched to him getting in that suitcase, and the rest, once that happened, the rest is history. And she took full advantage of the situation, and she left. She wanted him to suffer. And I do agree with this. Under the law, premeditation is not, it can happen in a second. There's no time constraints under the law for premeditation. However, I think the reason why she was charged with second degree and not first degree is because of the means, which was the suitcase. It's different when you pick up something that can first of all, is an actual weapon. That's its intent and its purpose. Like, a pew pew or a knife, right? Those are weapons, okay? But when the means is a suitcase, I don't think many people would think of a suitcase as being a weapon in that way. Now, if it were maybe like she locked, like say that they had like an old refrigerator that didn't work and she convinced him to get in the refrigerator and then she locked him in there. That's different, because anybody who was old enough to have watched Punky Brewster, I'm sure it's been on other TV shows, but my generation, we saw it on Punky Brewster about not getting into old refrigerators because they are sealed. And Punky had to give Alan CPR. So I think that's why they didn't charge her with first degree. What's Natasha saying? Let me see. Natasha says, many fail to understand you can still be a battered spouse and not suffer from battered spouse syndrome. So saying she doesn't suffer from it doesn't mean she wasn't battered. I agree. It isn't a plausible defense here. Okay. I agree that she was a battered spouse. I don't think that she suffered from battered spouse syndrome. I agree with you. I probably said that weird. I don't like to say suffered from, and my brain kept wanting to say suffers from battered. What I should have said was, I don't think that the diagnosis of battered spouse syndrome fits Sarah Boone. I think that I do think she was a battered spouse. I do. And I think that George was too. I think they battered each other. And, that's just how I feel. And I agree with this also, Peter. I really don't look at this any different than someone drowning someone. I agree with that. I mean, what she did was heinous. But again, if you're going to charge somebody with a crime, doesn't even matter what crime it is. Every crime is subject to double jeopardy. So in theory, you could always opt for a jury trial. And if you are acquitted, you are acquitted, and that's that. They can't charge you again. And so, but murder obviously is one of our most, if not the most serious crime that you can commit in this country. And I think that when you only have a one chance at that, at a conviction, I think that I think that there was some back and forth between the DA at the DA's office about what to exactly charge her with, and I think they could have charged her with premeditated, which is first degree murder, but I don't think they thought they would be able to convince 12 jurors of that. And that's also something we need to keep in mind when we're talking about this this whole defense that Owens is trying to come up with. The fact is, the burden is on the state, so the state has to convince all 12 jurors. Owens, he only has to convince one juror. He only has to convince one juror on that jury that Sarah does have battered spouse syndrome, and that her thinking was skewed because of that. And that is what and that is what happened, and acquit her. And he only has to convince one person. Do I think he'll be able to get that one? If not for those videos that she recorded, maybe. You know what, Yana? I'm going to have to look into that, because this situation with less jurors on the that are seated. I don't actually understand how. I need to look into it to better understand how that works, how they decide between having a panel of 12 jurors plus alternates, or 6 jurors plus alternates. I'm kind of interested. I need to understand that. And thank you for asking about that, because I do need to look into that. I'm curious how that comes about, and how they decide. Candace Bree says, prosecution once said it's easier to convince 6 than 12. That's true. It's easier to convince 1 than 6, which is what the defense has to do. So, all right, you guys, I've been on here for 2 hours and 30 minutes, and I can tell that I'm starting not making sense. Sunday Doodle says, Jen Lou, what do you think about the defense bringing up George's brother? Oh, I thought that was foul. I thought it was wrong. I thought that to connect those two, he did it because he knows dang right well that there's no way that's coming in front of the jury. Absolutely not. It would never be admitted. But what he attempted to do is put it out there in the public, for the public to listen to, and to maybe not taint the jury pool so much, but maybe what he actually implied is that George got what he deserved. He was a bad guy. His brother is a bad guy. They beat women, and he ended up dead. And so what? That's the attitude that Owens had, in my opinion, by doing what he did. And I just thought it was gross. Absolutely gross. Just foul. I can't believe he did that. I really can't. I mean, I do think, yes, Kathy, words get hard for sleepy time. TK Sewing Machine and Repair. There is another roommate interview. He says they were arguing. It got really loud. It's the interview where he talks about being up late, getting 3 hours of sleep. Huh. Okay, I will find it. I'll find it. And we will talk about it because I do want to have a Boone-a-thon and talk about all the things, Sarah, leading up to the trial, just so all these details are fresh in our minds when she does go to trial. And also because I think that in every case, even as much that has as information and documents and the facts of the case that have come out in Sarah, in the case against Sarah Boone, there's still stuff that we don't know, right? That hasn't come out, and there's always questions, and there are always some pieces of evidence that we're not exact. We know what they are, but we don't know how they fit in the context, in context to the crime and all of that. So we have the majority of the pieces to this puzzle, but I think the trial is going to complete that picture. And I don't think that, I think this might actually be a trial where I won't have questions that don't get answered, so I feel like, that's why we should do something right before her trial so that all of these details are fresh. And when we hear the information, if we had a question about it or didn't understand how it was connected, then we can maybe make sense of it. But anyway, I'm going to let you guys go for the night. I'm going to play the outro. I want to thank you guys all very, very, very much for being here. I appreciate it so much. Thank you for the support. To Lil Red and Mayla's mom, I hope everything goes good with your pupsters. To Shelly Beans, good nights. And I hope you get to feeling better. And I'm glad you're getting sprung from the hospital tomorrow. You guys have a great rest of your night. And I will see y'all tomorrow with something. All right? Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious content or effort was towards it.
No malicious. Finish her.
Minutes later.
We all do a little mad sometimes.
Man,